Good morning. My name is Christopher Earl Strunk. I'm coming to you through recording here at the Brooklyn Public Library. Thank you very much for allowing me to do this. I want to give a brief summary of what I'm doing at the Supreme Court. We just filed an original proceeding there under Rule 17, which was docketed on tax day, 15 April 2015. And that it's now got docket number 14-1238. I am in the case with a pastor on the West Coast from Oregon who has a Nevada state corporation soul for his ministry, Antioch Ministries. Ronald Dean Joling, who was for 20 years an independent trucker with his brother. He went into full ministry in '88 when he was ordained and has been refusing to use a 501c3 status, as it is an infringement upon his rights and his practice of religion. He is one of the few people I know who uses the Bible as a trust instrument to actually explain how we should or should not be operating on the present situation. He came to me at during the fall of 2013 to contract with me to straighten out his historical relationship as the surety indenture to his name in commerce, and that he had for 10 years been in a battle with the IRS, who had initially under the Bush administration had not challenged his trust structure for his church, and then under Obama, who is not who you think he is. He is quite a twisted character. Basically, they dragged him through a series of court proceedings, and he is about to be sentenced to 35 years in prison, or what could be 35 years in prison. We filed this case in order to get equity, not law, and that the district court, which is statutory court, is refusing to give equity review, and that we, as you may know, are under a martial process system, not a civilian due process system. Ever since 9 March 1933, when the FDR administration seized all of the property in all the states and turned them into territories during a time of war and emergency in collateral for the creditors of the debt. We've lived not under a trust arrangement as with the Constitution, and certainly we've lived under a statutory common Roman form of law, which is martial in its form, not civil in its form. By 1938, the governors had all agreed to fully incorporate their registration of all persons born in their territory by selling the instrument, the birth record instrument, to the United States, which is the owner of the title to the instrument, and will hold on to that instrument until the cessation of either a time of war emergency and or the individual ceases to be the combatant. Now, all surety indentures are owned by their name in commerce. You cannot operate in commerce without having a registered name. You can't have a bank account, you can't have a driver's license. All of that is impossible, and it's important that you reverse your relationship to that name so that you have full benefit of its use. Now, the way that they increase the debt ceiling, everything's done privately. There's no public accounts. Everything is run through the fractional reserve banking system. Since the gold windows were closed by Nixon, the Depository Trust and Clearing Corporation maintains a tab on where all the collateral security is, which is there to guarantee payment for the sale of treasury bonds and securities. And is used in other forms of private collateral security. So the minister came to me for the purpose of decoupling he and his wife from their surety indenture relationship, and which I have done. I released the state of birth and of residency of that trust obligation to essentially seize their property and their efforts in conjunction with the payment of the debt. So I register the non-surety status with the Secretary of Treasury and as a non-combatant, and with that the Secretary of Treasury under 12 USC 95 with the Trading with the Enemy Act 550 USC Appendix 5B has an obligation to release the property to the non-combatant, for the war is over for that individual in per se. They are in effect a pre-1933 private national citizen of the United States. Everyone else, even when they say they're private, they still remain, unless they've got special trust structures set up, they remain the surety for their public U.S. citizen. And that until they cease being the surety for their public U.S. citizen and reverse that trust relationship, then they will continue only to be accessed to administrative process. So this brief has been filed and has been docketed. The respondents have until May 15th to respond. In conjunction with that, I have, with Ronald D. Joling, I've co-published a Kindle book. This is a proof copy and a hard copy, but that I recommend that if you're interested in something that doesn't happen very often, an original proceeding in exclusive equity, that you get a copy of this on Amazon. It gets into the history, and the brief is actually included in it. As a result of being docketed and a request for leave to file a brief after May 15th, there will be a part 2. We will be filing a brief in exclusive equity, which is I've talked to a number of attorneys who have been amazed that I've been able to get as far as I have. And it's specifically because of my understanding of the way the system works. If I can, I go into contract, a private contract, if I can be of assistance for you in ceasing to be a surety, get in contact with me. My website is associationforsovereignhomerulewithin.org, or you can just Google surety no more, and it'll pop up on the top of the screen. Feel free to contact me. I charge $1,500 for registering you as a non-combatant. I am presently working with the Depository Trust and Clearing Corporation to get a certification of the segregation of the non-combatant from the 500-person bundle that was put together as collateral security, and that as long as it's commingled, you cannot use that equity. So I will turn your sole beneficial interest into possibly an EIN account where you will be able to contribute in commerce with that which is rightfully yours as a non-combatant. Feel free to contact me. And if you wish to take a seminar, Eric John Phelps and Rourke Edwards in a 4-day seminar for $2,500 in a class of 10 or under would be available twice a month anywhere in the country to do that. Otherwise, they do not go into contract per se. I do. So thank you for your time in watching, and enjoy the book. Thank you. All right, bye-bye.